Welcome to Epstein Becker Green's webinar, Value-Based Payments in Managed Care, the Legal Landscape, the fourth installment of our Value-Based Payments Crash Course webinar series. We are pleased to have Epstein Becker Green's Jackie Selby, member of the firm in the Healthcare and Life Sciences practice, presenting today's webinar. Before we begin today's presentation, please be informed that today's webinar is being recorded and that participant phone lines will be placed on mute throughout the program. You are welcome to submit questions directly to the presenter following the webinar, and contact information will again be displayed at the end of the presentation. In approximately 2 to 3 business days following the webinar, Epstein Becker Green will communicate the availability of the webinar recording and access to the PowerPoint materials. At this time, I'd like to turn over the webinar to Jackie.
Thank you, Sylvia. It's my pleasure to present today on legal issues in value-based payment and managed care. Today I will cover key variables or facts impacting the legal analysis of a value-based payment arrangement. They can be referred to as alternative payment models or any other term describing non-fee-for-service reimbursement arrangement. I'll use VBP. Second, I will provide an overview of laws that often apply to a VBP arrangement. And third, I will provide examples of legal analyses for 2 hypothetical VBP arrangements. This, of course, will be a high-level overview since we only have 15 minutes. Next slide, please. Legal issues for value-based payment arrangements in managed care vary depending on the type of payer, the type of product, the type of provider, and the type of payment, or 4 Ps that we can call them. And different combinations of each of these lead to different legal analyses, so it's important to identify which of these categories or which of the examples under these categories apply to your situation. Next slide, please. Now I will cover some laws that often apply to value-based payment arrangements. This slide shows 7 different areas of law that often apply. I'll touch on each of those at a high level, starting at the top with insurance and going around. Note that I won't cover other laws that might also apply to such an arrangement, such as HIPAA or tax laws. They really go beyond the scope of this crash course, but please keep them in mind when reviewing a VBP arrangement. Next slide, please. So starting with insurance laws, at some point, a value-based payment can constitute the practice of insurance, and this is a diagram that it's really a visual showing the spectrum of insurance risks for some of these types of value-based payments. The first one being fee-for-service really isn't a value-based payment, but you see going along the spectrum at some point insurance law is triggered. Oftentimes the dividing line is in the middle there with shared loss or downside risk, and obviously at the furthest end being paid based on a % of premium that the plan collects, or global capitation, for example, would trigger insurance laws. Next slide, please. So the NAIC defines health insurance risk as the uncertainty regarding the possibility of loss caused by bodily injury or illness, including medical expenses. Each state may define insurance somewhat differently. The bottom line is that anyone engaging in the practice of insurance would need to be licensed and have reserves for that risk. And some states explicitly permit insurance companies to share that risk with providers under certain conditions, for example, posting security or getting reinsurance or stop loss. And the degree of the regulation typically depends on the type of services that are subject to risk sharing, maybe one service, for example, maybe radiology, or all services in a population, in-network versus out-of-network services, or the type of payment that's involved. And for example, one state can regulate prepaid capitation payments, but not retrospective payments to providers. And then note that medical loss ratio requirements apply to insurers, and that the value-based payment arrangement would be taken into account likely towards those minimum MLR requirements, since it involves medical cost and very possibly quality improvement. Next slide. HMOs, of course, are licensed by states to take health insurance risk, and many HMO laws address when that risk can be shared with providers and others. Some states prohibit risk sharing with providers altogether. More states likely allow it but regulate it. For example, requiring approval of the agreement that has the value-based payment arrangement in it and possibly posting security for the risk, again, like reinsurance or stop-loss. And like insurance laws, the degree of that regulation depends on the degree of risk assumed. Also, like insurance, MLR requirements typically apply with HMO products, and the value-based payment arrangement would take that into account, or I should say the HMO would take into account those payments when calculating minimum MLR. And lastly, I just want to point out, I'm sure most of you follow the fact that changes are occurring in HMO and other managed care laws and are being driven very much, I think, by CMS's value-based payment initiatives or reforms for traditional Medicare, Medicaid. I used to call it fee-for-service Medicare, Medicaid, but that's not really the case anymore. So, for example, MSSP or Medicare Shared Savings Program payments to ACOs and MIPS payments for physicians and CJR, the bundled payments for joint replacements, are all examples of those reforms. I also mentioned the final Medicaid managed care rule. Even though it's managed care, not traditional Medicare and Medicaid, it takes into account VBP as well. Next slide, please. Some states are adopting VBP roadmaps in the context of their Medicaid reform for managed care and require managed care plans to pay providers based on value. This chart is an example, or is taken from New York State's value-based payment roadmap that was approved by CMS, and New York is requiring that 80 to 90% of Medicaid managed care payments be value-based by the end of 2019. So if you look at the chart, you can see on top that there are different levels of VBP from 0 to 3, and Level 1 is really upside-only shared savings. Level 2, some downside risk. And Level 3, more full risk, like global capitation for a subpopulation or the total population, or bundled payments, for example. Next slide. There are also intermediary network entity laws that come up oftentimes in value-based payment arrangements. These are entities that are not HMOs or licensed insurance companies, but yet arrange for healthcare services to be provided, and they may also be regulated by a state. And such laws or regulations in a state may often address value-based payment arrangements. These are some examples of different states and the different types of intermediary entities that they have laws addressing. I won't go through each of them, but there are, of course, many more in other states. These are just examples, so you should check your state laws relevant to the arrangement that you're working on. Next slide. Antitrust laws are often relevant in a VBP arrangement, for example, when multiple providers are negotiating that arrangement together, and federal and state antitrust laws may apply. And joint negotiation of any reimbursement terms, including value-based payment terms, may be permissible if the providers are either clinically or financially integrated. And otherwise, if they're not, they may need to use a messenger model arrangement for negotiating those payments. And value-based payments can constitute financial integration if there's substantial risk involved in that arrangement and shared among the providers. And note that government programs for VBP arrangements often include waivers of such requirements under the antitrust laws, but that commercial programs typically do not. Next slide. Corporate practice medicine and fee-splitting laws are also often triggered with VBP arrangements. Corporate practice medicine laws prohibit the practice of medicine and certain other services by general business entities, meaning not licensed providers, and fee-splitting laws prohibit professionals from splitting fees with non-professionals. And friendly PC-type models may be allowed in states that have those laws, but the rules differ by state and often involve issues like foreign qualification and stock transfer agreements. So it's important to do careful analysis of those laws if they exist in the state you're working with. And again, waivers may be permitted for government programs more typically than commercial with respect to such requirements. Next slide. Fraud and abuse laws mainly come up in the context of government program arrangements, but state laws can also apply to commercial programs. So it's really the federal federal laws that you think of in the context of government products. But even in a commercial context, patients may have Medicare as a secondary coverage, and in those cases it could trigger the government nexus for federal fraud and abuse laws to apply. And exchange subsidies, it's still unclear since they're federal money, it's unclear how the federal laws, fraud and abuse laws would apply. And what follows is really simply a checklist of fraud and abuse laws that might apply to your arrangement, so I would encourage you to keep them in mind when analyzing the VBP arrangement that you're looking at. And then lastly, there are often, of course, fraud and abuse type law waivers with many government programs, not so much for commercial. Next slide. And lastly for this presentation is a set of laws related to when plans delegate services to providers, which is often more the case when there's significant downside risk involved. For example, claims payment may be paid by the provider or a related management company on behalf of the plan, and it may trigger TPA licensure laws or claims adjuster laws, and the agreement itself may also need to be approved. And utilization review or reviewing claims for medical necessity on behalf of a plan often would require state licensure and approval of the agreement, and even credentialing providers on behalf of a plan may require approval of that agreement. Next slide. Now I'll use one hypothetical VBP arrangement to apply some of these laws at a high level, of course. As I said earlier, any combination of these would require different legal analyses. In this case, we'll take an HMO that has government products and it's paying, say, an ACO or an IPA based on shared savings only, not downside risk, for one service, let's say orthopedic services, and it would be based only on in-network services. Next slide. This is the same hypothetical in a diagram form. So the HMO, obviously if there's an HMO, the HMO laws apply. Because it's upside-only shared savings, it's unlikely to trigger financial risk-sharing requirements. But the shared savings arrangement would probably involve some kind of cost target with a set of quality metrics probably that have to be met as a minimum to share any savings, and those savings would be shared among the providers. And in this case, since the payment is going to an IPA or, say, an ACO with downstream orthopedists, most likely, or you should look at, I should say, intermediary network laws in that state, as well as pay attention to antitrust laws, because it's a group of providers negotiating together through their IPA or ACO. Perhaps they would need to use a messenger model. And because they're orthopedists, or physicians, the fee splitting and corporate practice of medicine laws in that state should be reviewed. And then because they're government products, the fraud and abuse laws especially should be given very close attention, and it involves physicians and referrals. So that should definitely warrant a close review. And obviously these arrangements can get complicated. The legal analysis can get more complicated than what we're saying here. Next slide. Another hypothetical VBP arrangement might involve an insurance company, and that's also a qualified health plan, meaning it has exchange products. And let's say they only have commercial products on and off exchange, whether it's fully insured or self-insured, and for individuals or groups, and that the payments would be going to licensed providers. In this case, let's assume a health system that has downstream providers. And The payment, let's assume, would be both shared savings and shared losses. So maybe some sort of target with, again, quality metrics whereby any savings and losses would be shared among those providers. In this case, assume multiple health care services and out-of-network services. Next slide. In a diagram form, obviously the insurance laws would apply as well as the QHP laws, and because it's shared savings and shared losses, and it's for all healthcare services in and out of network, it's very likely to trigger insurance risk-sharing rules, maybe requiring security or reserves. And because it's commercial members, the federal fraud and abuse laws may not be as relevant, but there may be a nexus if there are Medicare secondary payment issues, and of course look at state laws. And because it's physicians, you want to pay attention to whether any corporate practice in medicine or fee-splitting laws are involved. And I also mentioned administrative services, so you want to look at any separate licensure requirements if you're doing UR or paying claims. And that brings me to the end of this presentation. Thank you very much for participating.
This concludes today's webinar. In approximately 2 to 3 business days following the webinar, Epstein Becker Green will communicate the availability of the webinar recording and access to PowerPoint materials. Thank you, Jackie, for presenting, and thank you for attending.